a brief introduction of Statelessness and the work we do. So before we go into actually presenting the project that we're here for today, so Statelessness is a network made up of over 80 plus research volunteers. We research information for asylum claims, specifically researching information on country of origin of an asylum applicant or the country where the applicant used to live. This information is called country of origin information research. We provide this research to legal representative free of charge, on demand and case specific. We focus on research and do not provide legal advice. We research facts and do not give our own opinion or evaluation. And country of origin information is crucial in deciding whether an asylum applicant is in need of international protection. However, information categorized as COI, such as UN or NGO reports or media articles outlining human rights violations, is rarely published with asylum protection context in mind and might not be specific enough for an individual claim. Now, this together with the numerous barriers to conducting primary human rights research, such as security, access, language issues, funding, etc., lead to serious information gaps and asylum and human rights claims. At the same time, even where COI is available on an issue relevant to the asylum claim, it can be of poor quality. While accepted guidance sets out a lack of information on a human rights issue is not indicative that it does not exist. In reality, the burden to prove their case rests with the asylum seeker, and a lack of information can lead to their being refused protection and returned to their country of origin. There is therefore a real need and opportunity to address COI gaps in order to promote equal access to justice in the UK asylum system. So Statelessness attempts to fill these gaps by using creative COI techniques to generate new and high quality COI. To give you some background specifically on this project, in the first quarter of 2022, we conducted in-depth consultations with a range of stakeholders, from those with lived experience of statelessness to academics, lawyers, and NGOs with expertise on statelessness. These consultations provided us with invaluable insight. They helped us to identify information gaps and inadequacies in the available COI on statelessness. To supplement these consultations, we also conducted a rapid desk review of literature on statelessness and a review of which Home Office country policy and information notes, SIPINs as they're called, to address statelessness. Through these consultations, we sought to identify a research focus that could serve as a case study that provides relevant and up-to-date COI on a particular group of stateless persons, but also creates the opportunity to distill broadly applicable best practice principles when conducting COI research on the issue of statelessness. So in response to the issues raised through these consultations, and thanks to funding from Trust for London, Statelessness developed a project to address information gaps about stateless persons who are seeking international protection, focusing initially on stateless Palestinians in Lebanon, which served as a case study for us. Our work on this project has included an unpublished rapid review of existing COI, including governmental and intergovernmental sources. We were looking at how statelessness was covered in the sources, and we found a number of discrepancies in the COI, including complete gaps of issues of statelessness, lack of currency where statelessness related issues were covered, and a strong focus on laws, but less focus on how those laws are implemented. If you're interested, you can learn more about this point in our upcoming training Following on from this scoping of our work, we produced a country report on the situation of stateless Palestinians in Lebanon, which we published last week, and I hope we all received a copy. It combines interviews and with individuals with authoritative knowledge on the topic, including those with lived experience of statelessness, alongside excerpts from country information available in the public domain. We also published a principles document to guide those who are conducting COI research on statelessness related issue. And I'm going to briefly present the main findings, considering that we don't have a lot of time to discuss them. However, we have put the link to the report in the chat, and you should be able to also see the key findings summarized on that page. So the report itself is divided into 15 core sections. Each one is spotlighting pressing issues relevant to protection claims from stateless Palestinians and include risks from non-state and state actors alike. Our findings paint a troubling picture of the situation for stateless Palestinians in Lebanon, in which sources highlight the various forms of layers of discrimination perpetrated by state actors, as well as within communities and families. So this includes their right as stateless persons, which are set out in international agreements. Notably, Lebanon is not a signatory to the 1954 Convention, which defines and requires states to protect stateless persons. It also doesn't have any law that protects people who are stateless or who are at risk of becoming stateless. The report draws extensively on the insights and information from interviews and correspondence with 5 experts from Lebanon, some with lived experience of statelessness. This, of course, was particularly important to us as our experience conducting COI research for the project illustrated many of the challenges and limitations we noted in the desk review that I just mentioned. This includes a lack of visibility of stateless persons in public available COI sources, lack of reliable data, limited stateless specific sources, or general sources with stateless specific information. And finally, but not least, a lack of clear terminology distinguishing stateless persons in different situations who have different experiences of statelessness. We also looked into an intersectional approach, which unfortunately we were unable to see a lot of the feedback on any of the reports. And that's kind of like a summary of all the gaps that we had identified during our desk research. And I think I can actually hand over to you, Emily. Thank you all for listening.
Thanks, Fatima. So I think we're going to move on now to hear from some of our panelists, both on the issue of statelessness more generally, but also the situation of Palestinians in Lebanon. We've got quite a bit to get through, so Fatima and I will be keeping an eye on the time, and we might jump in at certain points to keep the conversation moving. But we're really excited to hear from everyone on the panel. So I'm going to begin with Anna, who is one of our fantastic researchers who made such a brilliant contribution to this project. I would like to get an idea, Anna, from you about what the research process was like for you, and maybe some of the challenges you faced in researching this research topic of stateless Palestinians in Lebanon.
Sure. Well, so the first thing really that I would say is that the research process itself, the way it was set up by Statelessness and by this team, was incredibly collaborative. First of all, we were put into pairs, but even within the larger team, we decided to divide the research based on the type of sources that we went through. So these were databases, governmental sources, think tanks and NGOs, media, academic sources, international organizations, and intergovernmental bodies. And just dividing it this way made sure that we covered all of these. I personally was tasked with reviewing media sources, and I was working with my colleague Dina Bastan, who was reviewing sources in Arabic, while I was reviewing sources in French and English. So again, just ensuring that this collaborative way of working actually covered so many like different linguistic areas was a real strength. Personally, I would also say that it was great practice to do this in pairs and as part of a wider team, both because of the encouragement that it provided, but also because we had the opportunity to exchange on the methodological difficulties that it just threw our way. And that brings me on to the challenges. So overall, much less information was available than what I had expected. And I think my expectation of that came from the relatively high media coverage of Palestine and that of Lebanon, particularly at the time when we were researching when the Beirut explosion of August 2020 just put Lebanon at the headlines. But very little was said about statelessness and the specific situation of Palestinians in Lebanon. So when I started researching, I realized that the word stateless itself is not going to give me almost any results. So instead I resorted to using keywords such as Palestinian refugees and migrants in Lebanon. I just put all of those in my search boxes in English. And in French, I actually had to cast my net even wider and looked at key terms like poverty, marginalized minorities, Lebanon, and of course ended up with like hundreds and hundreds of pages of articles, a big majority of which did not turn out to be relevant. And then finally, in terms of challenges, I mean, politics, of course, colored each and every media source that we were looking at. It was very different to lift a sentence from, let's say, the BBC to doing so from L'Orient Le Jour, which is like a local Lebanese newspaper. And so to tackle that, we just made sure that we understood the political standing of the source that we were lifting quotes from, and that also we integrated this, this understanding into the report itself. So you'll see lines to that effect.
Brilliant. Thank you so much for talking us through some of the things that you found really great about the research, and also some of the challenges which I imagine anybody else might face if they were also researching this topic. So moving on, I'm going to now ask a question of our panelist Stephanie, and this is a bit more of a generalist question about the issue of statelessness in the UK. So throughout the research process, we spoke to many individuals who'd somehow worked on statelessness. And one issue that was consistently raised with us was that there is a fairly low awareness of statelessness among different actors working in the field of immigration and asylum, including decision makers in the UK. On top of that, there's a link between refugeehood and statelessness. A person can be both a refugee and stateless. And there's quite often a strong focus on the persecution element that individuals might face, and perhaps less attention on the issue of statelessness and the protection issues and rights-based issues that may arise from the statelessness itself. That's kind of a general background to our research. Thinking about the legal landscape in the UK, in your view, could you give us a bit of an overview of what the current challenges are for legal representatives when dealing with cases involved in statelessness? And feel free to also mention your work a bit as well, in general on nationality law and statelessness.
Hey, thank you very much. Yes, as I said in opening, statelessness arises in a number of different contexts. It has predominantly arisen in the context of protection claims, but also increasingly over time in the context of removal, where a person has been detained or they face deportation, but it's proved impossible for the person to be removed to the putative state of nationality. And of course, as I said, in deprivation context, which has become increasingly high profile. Obviously, people will be aware of the case of Shamima Begum, but that case represents a large number, significant number of people who've been deprived of their citizenship whilst outside of the jurisdiction, often trapped in camps in Syria. So it's arising in a number of different contexts, but there are common issues that explain the phenomena that you've said. First of all, of course, you have to recognize that the people who may be stateless come from very marginalized communities. They may have faced discriminatory denial of rights in their own country, and therefore they are not generally necessarily going to be asserting their claims to be stateless. So you have to be proactive about it. The second thing is that it's extremely complex. There are very many different ways in which a person may become stateless. It can occur because of discriminatory practices, whether that's on race, religious, or gender grounds. It can arise because of cessation in states, so that may arise because of conflict, such as Ethiopia, Eritrea, where there are lots of disputes about nationality over those states when they divided through civil war. Or you have situations where there's decolonization was a big way in which there was creation of statelessness. And of course, you also have breakdown of states, like in the Soviet Union, and the Eastern Bloc countries created large numbers of difficult situations to do with statelessness and ambiguity about which state a person belonged to, if any. So they're complex situations that raise difficult questions of fact and law about the breakup of states and the consequences of it. There is also the fact that there's no real universal definition of what stateless means. So whilst you have a definition in the 1950s Convention relating to the fact that the person is not considered to be a national by any state under the provisions of its laws, the question of what its laws mean has not had universal definition. It's a point of customary international law. In the UK, there's been a big debate about de jure in law or de facto in practice. Our courts have adopted a middle ground to some extent in a case called FAM, which is the leading case. It said that whilst the primary question is what's the position in law, they will look at what the practice is. But looking at what the practice is has proved very difficult and has also not been very firmly established the extent to which practice is going to be a key issue. So there's uncertainty in the law, and there's also then the difficulty of proving both the legal position and in practice, because as you've indicated already, one of the speakers, the burden is on the individual to prove it. And the leading case in the context of somebody asserting the right, asserting that they're stateless, is a case called A.S. Guinea and the Secretary of State for the Home Department, which is decided by the UK courts in Court of Appeal in 2018. And that court, contrary to the guidance and advice that was given by the UNHCR, the UN, in its handbook on statelessness, which asserted that actually the state and the individual should share the burden of proving statelessness, because it was recognized by the UN, just as it is in protection claims, that there are formidable obstacles to individuals proving whether or not they're stateless. And therefore, there ought to be a shared burden. And also in the handbook, it asserted that in recognition of the difficulties inherent within proving statelessness, that it ought to be that the burden of proof was a low one. So there's similar to what had been recognised to be the position for refugee claims. It should be a reasonable degree of likelihood rather than proof. The court, however, rejected all of that. It saw that the handbook was persuasive, but nevertheless came to a conclusion that you have to prove as an individual statelessness on the basis of the balance of probabilities. So ordinary civil standard, because they said you can distinguish refugee claims because this is only about past facts, not future risks, and you're not at risk of persecution necessarily if you are saying you're stateless, as opposed to claiming to be a refugee. Even more difficult and more challenging, the court said that there was a burden on individuals to take all reasonable steps to provide all the relevant documents, and even to show that they have sought and been denied citizenship in their country. And clearly that therefore means for a person whose statelessness is part of a protection claim, they are put in the impossible position of being asked to contact the state in which you say would persecute you in order to prove that you're stateless. And that goes against all the recognized protections that there are, that in fact a claim for protection should be met with confidentiality. The other state shouldn't know about it at all because it may result in reprisal to you if you are returned, or of course family members or others linked to you in the country of origin. And so it creates this impossible position, which means that individuals generally would choose to pursue their protection claim rather than their statelessness claim. And of course, under the Refugee Convention, if you were to be granted, acknowledged, recognized to be a citizen, you could be seen to have voluntarily availed yourself of the protection of the state, which would be counter to your asylum claim, even if there was evidence that you'd be persecuted. So that's a very big disincentive to pursue the two at the same time. In the context where you may only stay asserting your stateless, for example, in the categories of case that I've talked about, where it's about removal and you've not been able to be removed, you've been in detention. I've had clients for many, many years, months, where the UK is trying to get the other state to receive them back. Those category of cases generally have problems with credibility. The Home Office will challenge the credibility of the individual, and whatever information they've provided will use the fact that the other state hasn't accepted them as evidence that they've not provided all relevant material, or they've given misleading information. So you're very much in a catch-22. In the deprivation context, you have all of those problems, because even though you cannot deprive a person of their British citizenship normally if they are stateless, they face all of the same problems. In order to do that, they have the burden and standard of proof is the same. And in addition to that, many of these people are outside of the jurisdiction. So they're having to produce evidence in circumstances where they can be in camps in Syria, where there are real problems with access to legal advice and to confidential legal advice, and that creates additional very significant problems of evidence. And so again, although there have been cases that have succeeded in challenging the deprivation decision on the grounds of statelessness, that is become increasingly more difficult. And it has the problem that they will look at the date of the decision. So someone, for example, like Shamima Begum, who was in law entitled to Bangladeshi citizenship, although she'd never been there, she didn't have a passport, and Bangladesh had indicated they wouldn't accept her back. She still did not succeed on that basis. And now, even though her case was only heard very recently and she's over 21 and wouldn't be entitled to Bangladeshi citizenship, that's not going to avail her because they're looking at the date of the decision. And if I could just add one final thing, I think the overall difficulty that we face is that, particularly in the United Kingdom, there is not sufficient weight and importance given to citizenship. It's treated as a privilege, not as a fundamental right. We know that it's the right upon which all other rights are based, but it has limited protection. And that, unfortunately, also, I think, to some extent is reflected in the ECHR jurisprudence that still treats citizenship as an administrative decision, so not entitled to all the full protections of Article 6 of the Convention on Fair Trial Rights. And so it's a weak protection. But I think practice is showing us in many different ways how critically important that right is, and why we need to have further a re-evaluation and reassessment of what sorts of procedural protections are necessary to ensure that this most critical of rights can be effectively asserted in courts and obviously enjoyed. So I hope that's an answer to your question.
Thanks so much, Stephanie. That was amazingly broad ranged and detailed. So interesting. Over to you, Fatima.
Yes, thank you very much, Stephanie. That was a great overview for everyone who either is familiar or not familiar with not just the concept, but also the issue at hand in terms of the UK asylum itself. So that actually leads me to a really great question now, specifically within the title of our work. And it leads me to Cynthia. And the question would be it's a question that kept coming up during our research, which was basically whether or not, or whether or in what circumstances Palestinians should be considered stateless as a matter of international law. And I was hoping that today, if you'd be able to share your thoughts on this question with us.
Thanks. I'm happy to give it a stab. It's a very complicated question in some ways, and in other ways a little bit more simple. It is discussed in a report that I drafted for the European Network on Statelessness and Badil last year. It was published in July 2022. So regardless of what I say today, it's probably going to be useful to have a look at what we put into the report. And I just want to preface what I'm about to say by saying that, of course, it's really important to recognize that many Palestinians self-identify as Palestinian nationals. Palestine is recognized as a state by the United Nations and 139 countries. Palestinians have a right as a people to self-determination, and they have a right under international law to hold Palestinian nationality, and they are being denied that right on an ongoing basis. Despite all of that, I think there are very compelling reasons why most Palestinians who don't have a nationality other than Palestinian should be considered stateless and protected under the 1954 Convention relating to the status of stateless persons, or the 1951 Refugee Convention, depending on their circumstances. And there are two main reasons why Palestinians should generally be considered stateless. First, although Palestine is a state, it's not a fully sovereign state, and it's not a fully independent state. It is occupied by Israel. Israel controls exit and entry into the Palestinian territories, and it also controls the issuance of documents like identity documents and travel documents to a large extent. And then secondly, Palestine doesn't have a nationality law. There have been some efforts by the PLO and the Palestinian Authority to enact a Palestinian nationality law in 1995 and in 2012, but these efforts failed. There's also something called the Palestinian Basic Law, which was enacted in 1997 as a temporary constitution until Palestine is fully independent. And that law discusses nationality, but it doesn't define who is a Palestinian nationality, a Palestinian national. And it refers to citizenship being defined and regulated by law in the future. So it anticipates that there will be a Palestinian nationality law, but at the moment there isn't one. And so we don't know, nobody knows what the content of a future Palestinian nationality law will be. We don't know, for example, whether it will include people who are descended through a Palestinian female line rather than a male patriarchal line. We don't know whether it will include people whose families left Palestine before 1947 or some other relevant date. And we don't know what evidence of Palestinian ancestry might be required and how people will be treated if they can't produce the right evidence. So until some of those really big questions are resolved, Palestinians should be considered stateless under the 1954 Convention, and they should be protected as both stateless persons and refugees. And none of that should be taken to negate any Palestinian rights under international law to be recognized as a national people, or to have their state be recognized as a state. But it does take into account the current realities for Palestinians in much of the world.
Perfect. Thank you very much, Cynthia. Right, well, taking a step back and thinking about the response to statelessness within the UK, I have a question for David Neal. What could be done to strengthen this in your view, and how could COI play a role?
Okay, so I think Stephanie has obviously set the scene with how statelessness relates to UK immigration, asylum and nationality law. And I want to expand on that because, as Stephanie highlighted, the major difficulty that a lot of stateless people have in a range of contexts is proving that they are stateless and proving the other things they need to prove to establish a claim. And this can arise in our system in a range of contexts. Firstly, in an asylum case, a person's fear of persecution might be due to being stateless, as with the Kuwaiti Badoons, or they might have been arbitrarily deprived of nationality, as with some ethnic Eritreans in Ethiopia. for example. Another context is paragraph 403 of the immigration rules, which provides a route to leave to remain as a stateless person. That requires you to prove not just that you're stateless, but also that you're inadmissible to your country of former habitual residence or any other country. So being stateless alone is not sufficient, but that route doesn't require you to show a fear of persecution, unlike asylum. Thirdly, as Stephanie highlighted, where a person's being deprived of British nationality, it's often necessary to determine whether the order would make them stateless. And that, as Stephanie highlighted, that gave rise to what is the leading case on statelessness in the UK, which is the Supreme Court decision in FAM. And fourthly, you have, in some circumstances, a stateless person may have a right to be registered as a British citizen. For example, traditionally, stateless children born in the UK have had an entitlement to be registered as British citizens. That's now been rolled back somewhat in the Nationality and Borders Act because there was a kind of loophole arising from the case of MK India, where if you were born in the UK to Indian parents and your parents hadn't registered your birth at a consulate, you were formally stateless. And the government's now cracked down on that in the Nationality and Borders Act by narrowing that route. In some circumstances, people who hold other forms of British nationality, such as British overseas citizenship, but are otherwise stateless, can also register as British citizens. So there's a whole range of circumstances in which you might need to prove that you're stateless. And as Stephanie highlighted, this poses a lot of challenges. The burden of proof is on you, the individual. You may or may not have access to legal aid and legal representation. Legal aid's available for asylum cases, but not generally for most other types of immigration case. Now, as far as the UK response to statelessness is concerned, obviously our current government very hostile and anti-migration, so we can't realistically expect any policy improvements in the foreseeable future. But what we can do for us as immigration practitioners is work to improve our own response to representing stateless people and securing better outcomes for them. And I think COI research can play an immensely important role in that. And I think it can do that in three main ways. First of all, COI research can shed light on the nationality law of the country or countries concerned. So whether a person is a national of a particular country is a matter for the law of that country. And the Home Office often kind of mangles this issue in decision letters. They'll often kind of assert that someone is entitled to the nationality of a particular state based on some stuff that the decision maker has found on Google and misunderstood. So the quality of decision making is very poor in that regard. But obviously, this requires a tribunal on appeal or the High Court on a judicial review to determine the content of a foreign nationality law. And that gives rise to the question of how the court should do that. And there's some difference of opinion about this in the case law, because the traditional approach is that foreign law is a question of fact and it needs to be proved by expert evidence. So on this view, a British judge shouldn't go and look at foreign legal materials and draw their own conclusions about what they show. It needs to be advised by an expert who's a lawyer in the country concerned. But obviously that's prohibitively expensive and inaccessible for a lot of people seeking to establish statelessness claims. In the case of MK that I mentioned earlier, Mr. Ockleton, the deputy judge in that case, adopted the traditional approach and said you need expert evidence. But actually, the Court of Appeal in the case of KV Sri Lanka took a more liberal line on this. They took the view that it depends what country. They said basically, if it's a country that doesn't share a common legal heritage with the UK and the legal materials are in a foreign language, then you're likely to need expert evidence. But if it's a Commonwealth country that shares the English common law and the legal materials are in English, then there's nothing wrong with the English court looking at those legal materials and drawing conclusions for itself. But in practical terms, even where expert evidence is really needed, it's often just simply inaccessible because the individual may not have the benefit of legal aid, they may not be able to afford an expert report, and even if they can, there's a lack of properly qualified and independent experts in the context of some countries. So COI research can provide an immensely useful tool in this regard in providing a baseline of accurate and reliable and properly researched information about foreign nationality law. And while it doesn't replace, obviously, expert evidence from a foreign lawyer, it's still a lot better than the court having to do its best with no input at all. And I think this project on stateless Palestinians in Lebanon is a good example of how valuable that can be, because of course with a multilingual team of researchers, they were able to look at sources in languages other than English. Obviously, if I, as a practitioner, and am conducting a Google search and looking for country resources, I'm going to be limited to sources that are available in English, which in a lot of countries is only going to be a small fraction of what's actually available. So I think COI research is absolutely vital in this area, and it really helps practitioners a great deal, and particularly so when you've got a country that is not a common law country, where English lawyers aren't necessarily going to be able to just look at the text of the law and understand it, and we're going to need some input from stakeholders who are able to provide more accurate information. A second area where COI research is really important is to document the actual practice of the country concerned. As Stephanie highlighted earlier, the Supreme Court in FAM made clear that statelessness isn't always just about the text of the nationality law of the state in question. Reference can also be made to the practice of the government, even if it's not subject to effective challenge in the courts. So it might look on paper like someone is a national of a particular country, but the administrative practice might be to deny them nationality. And that's particularly relevant in the case of states that have a weak rule of law and a weak judiciary, where you can't necessarily go to court to vindicate your rights. In that context, COI research is absolutely invaluable because it can provide up-to-date, reliable information about the actual practice of the country concerned and how it might differ from the text of the law. And obviously, this also goes to issues other than whether the individual is stateless, such as the issue that arises under paragraph 403 of whether they are admissible to the state concerned, because that can be a significant burden. For example, the case of Ter concerning a Malaysian British overseas citizen who had renounced his Malaysian nationality. It was accepted that he was stateless, but it was held that he was still admissible to Malaysia on the basis of evidence of state practice. So that's another very important area where COI research can play a huge role, as it obviously can in determining whether stateless people are at risk of persecution or at risk of denial of basic rights in their country of habitual residence. And the third area where COI research can help is the issue of credibility, because across the board, in all types of cases, the Home Office will assess someone's credibility. It will often accuse them of lying, and it'll often accuse them of lying on a completely spurious basis. It'll often say you're not credible because we don't think it's plausible that this would have happened to you, or what you've said doesn't match something that we found on Google on a random website and didn't understand, so therefore you're not credible. COI research can help to rebut that narrative by situating a person's account in a factual context of what actually happens in the country concerned, and can therefore really help practitioners who are representing a stateless person to establish that their account of their experiences is credible. And obviously that can go both to whether they're stateless in law and whether they're treated as stateless in fact. On both of those questions there, the credibility of their account may be very important. So overall, COI research can fulfill a crucial role in helping immigration practitioners to represent clients more effectively and deliver better outcomes for clients. It's very, very important, and it's particularly vital in the context of our current situation in the legal system, where legal aid isn't available for a lot of cases. People often have very, very few resources and are not able to commission their own expert evidence, and are going to be reliant on what's available out there in the public domain. So it's absolutely invaluable. It can really help to shape practitioners' response to statelessness cases. And as I say, this is something that comes up in a whole range of contexts, from asylum to paragraph 403 to nationality law. So I think that is essentially my approach to that, and I think we need more of these reports on more on more groups of stateless people and more countries.
Thank you, David. That was equally amazingly detailed on the value of COI. Just then taking a step back into the specific project that we're presenting today on Palestinians in Lebanon, I'm going to direct a question to Shahad, who was a really valuable contributor to our steering committee. So one of the issues that we discussed a lot during the development of this research was that individuals who are experiencing statelessness may not themselves even be aware of the concept of statelessness, and they may not choose to identify as stateless for a variety of reasons. Cynthia's already kind of alluded to this point. I wonder if you could elaborate on this a little bit and share a little bit more about why Palestinians may not identify themselves as stateless.
Thank you, Emily, for this very important question. And I think what has already been said feeds into this. First, Anna mentioned the difficulty of having resources on Palestinian statelessness in general. And this is one of the things is that Palestinian generally were always referred to as refugees rather than stateless people. And the translation of stateless from English to Arabic also might play a role in how people identify themselves and why they don't refer to themselves as stateless, but more as refugees. And the second thing is the existence or the recognition of a Palestinian state at the UN, even that the UN recognized Palestine as a non-observer member state in 2012. Palestine until today does not enjoy full sovereignty, or it's not an independent state, and they don't have nationality laws until today. So if we revise the definition of who is a stateless, so under international law, the stateless is someone who is not recognized as a citizen or as a national by any state under the operation of its law. So there are three components here: the national, the state, and the operation of its law. And when it comes to Palestine, the state is questionable because Palestinian statehood is still under examination. And then Palestine does not have nationality law. So that national, who is a Palestinian national, and why do Palestinians refer to themselves as national rather than stateless? Palestinians until today, they identify with the land of historic Palestine. So the connection to Palestine, their belief and their demand to the right of return and right to self-determination and the recognition of Palestinian nationalhood and national rights worldwide make Palestinians refer to themselves as nationals rather than stateless or refugees. As important as it is to recognize Palestinian refugeehood and Palestinian statelessness, the unique position of Palestinians under international law makes them refer to themselves as nationals, because even if a Palestinian was recognized as a refugee or as a stateless in a certain country, they would still have the right of return to an independent Palestinian state once a state is established. So, for example, some Palestinian refugees in Jordan, they were naturalized and they have a Palestinian nationality, the Jordanian nationality, but UNRWA still treats them as Palestinian refugees and they still receive assistance from UNRWA in Jordan. So the fact that Palestinians fight for collective rights, for national rights rather than individual rights, makes them refer to themselves as Palestinian nationals rather than stateless or refugees. The second part, and it's the most important thing, this is a statement. It's a call for the international community and states in general to listen and to hear to the demands of Palestinians. Palestinians demanding freedom, statehood, national rights rather than individual rights, because usually when we study the status of a refugee or of a stateless, we refer to them as an individual. And as important as it is to recognize the individual rights of a stateless and refugees, it's also very important to recognize and acknowledge and actually fight for the rights of Palestinian national rights. And this is mainly why Palestinians refer to themselves as nationals rather than stateless.
Thanks, Shahad. Brilliant. Over to Fatima.
Thank you very much, Shahad and Emily. So I think now we can maybe go back another step again and go back to Cynthia and the joint report with Badil and the European Network on Statelessness, which she had drafted last year. So there was a really interesting case that you had highlighted in this particular report, Cynthia, where the Court of The Hague examine the situation of Palestinians in Lebanon and their potential ability to regain access to the country after departing. Could you possibly briefly summarize the case to those who may not be familiar with it and explain a bit about the wider significance?
Yeah, sure. Thanks, Fatima. So this case is very memorably numbered, case 20.17797 in the Dutch system. And I will also just preface my remarks by saying that the case is reported in Dutch, which is not one of my languages. So I relied on a summary by ECRE and with some further information from a couple of Dutch lawyers who are specialists in statelessness. So I'm sure that their information is reliable. Just as a summary of the case, it concerned a stateless Palestinian. The case doesn't give his name, so I have to refer to him as the applicant. He grew up in Ain el Helwa refugee camp in Lebanon, and he eventually traveled to the Netherlands and claimed asylum in 2019. He was initially refused on grounds relating to credibility, and also because the government considered that he was excluded from refugee status under Article 1D of the Refugee Convention, because they said he hadn't shown to a sufficient standard that he couldn't access the assistance or protection of UNRWA. And so they felt that he was not entitled to refugee status and that he was excluded from it. He then submitted a new asylum application, and that was rejected by the Dutch government, and they alleged that he had raised no new elements in the second application. That decision was issued in September 2020, and he appealed to the Court of The Hague. The Court of The Hague decided the case in June 2021, and they found that the country of origin information did show that conditions in Lebanon had gotten much worse than the first time he had claimed asylum in 2019, and in particular for stateless Palestinians, and in particular for people in Ain el Helwa refugee camp. And they cited some of the reasons for that relating to the pandemic, relating to the explosions in Beirut, which were mentioned earlier, which had a massive impact in Lebanon. They displaced over 300,000 people and caused a huge amount of damage. And the court also considered whether UNRWA was able to provide adequate assistance to Palestinians in Lebanon. And they noted that UNRWA was undergoing a very serious funding crisis, and it was questionable whether the organization had the ability to meet the needs of Palestinian refugees. They also noted that many Palestinians had become increasingly entirely reliant on UNRWA to meet their basic needs. And so it was a really big question about whether UNRWA was able to adequately support them. The court concluded that the country of origin information showed that there was material new information which the Dutch government should have considered, and that there was a change of country conditions that could affect the outcome of the case. And so they remitted it to the Dutch government for further consideration. At the time that I was writing this report, that was the situation for the case. I have gotten a little bit further information just very recently today, in fact, and there is a further appeal still pending with a higher court in the Netherlands called the Council of State, and it relates to quite technical and complicated issues relating to Article 1D, and I'm not going to go into them in detail because we could be here for years talking about Article 1D. And we don't have time for that. But I think that a couple of the lessons from this case are that, of course, accurate and up-to-date information about country conditions is really, really vital. And it can potentially save lives. And so really, really important. It also illustrates the really serious difficulties for many Palestinians as both stateless people and as refugees, subject to a special provision of the Refugee Convention, Article 1D. There is a real lack of awareness amongst government decision makers and judges in many countries in Europe and elsewhere about the conditions in Lebanon and in other UNRWA areas. about the inability of UNRWA to adequately protect or to assist Palestinians, and quite often a lack of awareness about whether Palestinians can in fact return to an UNRWA area at all, or move within UNRWA fields of operation once they're in that part of the world. And so I think the Asilos report will be really, really useful in filling some of the knowledge gaps, and hopefully people in government and judges will read it and take the information on board and use it wisely. Thanks for preparing such a very comprehensive report. My big worry is that within a few months it will need updating, or possibly within a few days it will need updating. And I think that there's a real tendency within governments, and especially to look at what's written on paper and not think, oh, well, that was the situation on the 3rd of March, 2023. Let's see what the situation is now, and do a bit more digging to see if things are still as they were. And that's really, really important, that we can't just accept what's written on paper. We have to kind of keep updating and keep learning what's happening in the current situation.
Perfect. I was just gonna, Emily.
Yes, thanks, Cynthia. Now, just briefly going back to Shahad, one of the key points outlined in the report is that Palestinians in Lebanon have different statuses, and with those statuses come different entitlements, particularly with regard to UNRWA provision. This is a big question, but I wonder if you could maybe briefly, in a few sentences, tell us a bit about why these different statuses exist, and particularly how they link to UNRWA provision.
Thank you, Emily, again. So just in short, there are different categories of Palestinian refugees, stateless Palestinians in general, but particularly in Lebanon, there are 4 different categories of refugees there. There are Palestinian refugees who are registered with the UNRWA, and UNRWA defines Palestinian refugees, or what they refer to them as Palestine refugees, as refugees who were forcibly displaced in 1948 after the establishment of Israel. So those refugees are the ones who are eligible for UNRWA assistance, and they are registered with the UNRWA, along with their descendants, obviously. And then we have the non-registered refugees, who are Palestinian refugees registered with the Lebanese government, but not with the UNRWA. And to a great extent, they cannot enjoy UNRWA assistance or protection, although in recent years, UNRWA started providing them with assistance as well. And then we have the non-ID refugees, who are basically Palestinian refugees who are not registered with neither UNRWA or the Lebanese government, and they don't have any legal status in Lebanon. And then lastly, we have the Palestinian refugees from Syria who escaped the Syrian war and settled in Lebanon. And just to mention that neighboring Arab countries did not really allow huge numbers of Palestinian refugees from Lebanon to enter into their territories. So the number of Palestinian refugees from Syria, dominantly in Lebanon, but they're still deprived their rights to register there or to have a legal status either. So the different categories do not really indicate that stateless Palestinians in Lebanon enjoy or have access to rights. The situation of Palestinian refugees and stateless Palestinians in Lebanon is still very critical. And despite the crucial and very important work that the UNRWA does with Palestinians in Lebanon, it's very important to mention that UNRWA is a humanitarian agency. It provides them with a humanitarian assistance rather than legal and political protection. And this is one thing that needs to be discussed in the context of Palestinian statelessness and refugeehood. The exclusion of Palestinians from the international protection regime for both refugees and stateless persons put Palestinians in a very critical situation under international law and national laws as well. The lack of a unified statelessness determination procedure and refugee determination procedure as well put Palestinians in a legal dilemma where they don't really have access to rights similar to other stateless people or refugees. And this is one of the things that we should look into when we study the different categories of Palestinians, whether in Lebanon or elsewhere, is that the legal protection that Palestinians need and the political protection that they need is crucial, and it's one of the key aspects of the Palestinian question in general. Add to this that Palestinians are not allowed to naturalize in neighboring Arab states, and this is due to the Casablanca Protocol, which is basically an agreement between Arab states not to naturalize Palestinians, and this is in support of their right of return and delegitimize the colonization and occupation of Palestine. So this also leaves Palestinian children born in neighboring Arab country at risk of statelessness, especially that most Arab countries where Palestinians currently reside have discriminatory, gender discriminatory nationality laws. So basically, if a Lebanese mom, for example, is married to a Palestinian man, the mom is not allowed or not able to pass on her nationality to her children who are of a Palestinian father and a Lebanese mom. And this increases the risk that such children can face further human rights violations and further marginalization as well. So that's exactly why Palestinians should be considered and should be recognized as de jure stateless individuals and refugees under international law and within nation states.
Wonderfully put. Thank you very much, Shahad. So now we've kind of discussed like a range of like from definition of statelessness all the way to the implication of laws and how we should be, or what kind of information COI helps with finding out. So now I'm just going to refer to Anna, and as obviously Cynthia just said as well, that when it comes to COI, it is something that needs to be updated on a regular, in order the situation can drastically change in such a small time. So we would like to, of course, we've worked on a document which my colleague Emily will discuss with you a bit more about the principles of research, but we would like to touch with Anna in terms of what are your top tips for people doing COI research on statelessness?
Sure. So yeah, there is so much to say, so many tips to give, but fortunately all of that is compiled in the principles. I've just chosen my top 5. The first one would be, which I already mentioned, is to cast your net very wide in terms of the keywords that you're using in whichever language you are researching. So for example, for me, the French equivalent of statelessness, apatrie, didn't yield almost any relevant results. But to be honest, I didn't get very far with stateless either in English. The second would be aware and read up on the political context of statelessness and of the specific population group that you are researching, because it will inevitably color the tone of the sources and the articles that you are reading. And it's only through knowing that background that you'll be able to sift through the information and take out what's really relevant for your research. The third one, very practical one, would be to make sure that you have subscriptions and or access to local newspapers as well. I personally have used the L'Orient Le Jour, so the Lebanese local newspaper, a lot. And it's not that it's completely unbiased, but it does give you a more in-depth view on what is happening on the ground. My fourth would be to, it's an obvious one, but just make sure that you speak to the experts, involve stateless people in your research, both as respondents, but also from the very start of your research when you start designing your methodology. And then finally, and this is probably because I'm an extrovert, but work in teams, because the research is going to be difficult. You're going to hit some dead ends and some methodological tricky parts. And it's just been so helpful to be able to talk that over with someone rather than to run the same loops inside my own head.
Thanks so much, Anna. That's really great to hear the tips from you as you did this research. I think it's also a good segue into the next part of our session today, which is to look very briefly, because we're running over time a little, at the principles document that we produced alongside this report. And the idea of that principles document is to basically equip people with the tools they need to start doing research on statelessness, not just on Palestinians in Lebanon, but to have a set of principles that they can begin to research any case potentially involving statelessness. Firstly, it's important for anyone embarking on researching statelessness to find out whether the person the country of habitual residence where the person is coming from is a signatory to the 1954 Convention on Stateless, the status of stateless persons. As already mentioned in the session, not all countries are signatory to that. And even if the country is a signatory to that, we also know that the law can be interpreted and applied in different ways, which can give rise to conflicting perspectives regarding whether a group is considered stateless. So you should look at that, and you should also look at whether statelessness is defined in the domestic law of the country of habitual residence. Secondly, COI, for good reason, often focuses on the present conditions in a country. However, in the case of statelessness, it's also really important to have an understanding of the root causes of a person's statelessness, and that will often involve looking back and understanding some of the historical circumstances that led them to be in that position of statelessness today and what's perpetuating it. We see that especially in the case of Palestinians, for example. So one of our recommendations is to actually look at the history of the laws and policy frameworks and why it is that that person within that group might be in a situation of statelessness today. Thirdly, one of the most fundamental things we needed to get to grips with at the start of this research was terminology. As has already been mentioned by different panelists today, there are different terms used to refer to Palestinians, subgroups, if you like, and those terms designate specific statuses and entitlements, and often whether that person gets UNRWA provision or not. So understanding terminology really helps us to better understand what we were seeing in the COI. So our recommendation when it comes to terminology is to try and develop an understanding of the relevant terminology in that context, including the words used to describe statelessness in the country of habitual residence, who they refer to, and the meaning that those words actually carry. But we do also want to acknowledge that there are limits to terminology in any particular context, and that many people may be stateless or at risk of statelessness, even in the absence of a relevant terminology to describe that situation. Then moving on, as has already also been referenced, there is no single kind of experience of statelessness. Even people within the same community may experience their statelessness differently due to other factors such as sexual orientation and gender identity, age, class, physical and mental ability, to name just a few. So it's really important to also look at other sources of social disadvantage that may act alongside or interact with a person's statelessness, and to try and illustrate through the COI how that plays out. Next, it's really important to, as many people have mentioned, look at the laws and policies that are in place, but also have a really good look at how those laws and policies are actually being implemented, and whether there are gaps between what the laws say and what's happening in practice. And finally, it's a very important point, and it has also already been mentioned, it's really important to actually realise that the need to include the voices of people, of stateless people, who have knowledge and insight into their own experiences that aren't available to us, maybe as researchers who have not experienced statelessness. So we have a whole set of recommendations along those lines as well. That was a whistle-stop tour. You can have a look at the principles document yourselves and digest it all in kind of at your ease. And now over to you, Fatima.
Thank you very much, Emily. I'd like to say thank you all for the panelists for all the insight that you've already given. I'd like to say thank you to the audience for listening to us for so long. And we did try to impact everything into a very short space of time. And as Stephanie said, the conversation about statelessness is such a deep and extended one that it's not something that we can put into a quick 40-minute discussion. So I would like everyone to possibly continue to read on the subject, in particular to look into our report and see if there's areas that you could get more knowledge on, etc. And then, of course, with our principles document, it will definitely be able to give you an insight on how to do the research yourself, regardless of the population that you'd be looking into. On that note, I would like to say thank you again, and we are now should be opening to questions and answers. So if you have any questions, we would really like it if you could either raise your hand or put it in the chat, and we'll try to get through them we have about 10-15 minutes to work through them. So, okay. Laurence, can you show me any questions? Okay.
Celine, you've got your hand up.
Yes. Thank you. And thank you everyone for your really informative presentation on everything. I have quite like a specific question, and maybe I think Cynthia touched on it most, but if anyone else has like insights on it as well. I was curious about like the Dutch case that you were mentioning, because I've read into multiple Belgian cases as well that were also mentioned in the report that you worked on, and wherein they talk about that UNRWA is no longer adequately able to fulfill its mandate, and therefore Article 1D has effectively ceased for applicants. And I saw those cases were mostly in, I think, either 2020 or 2021, and that there was kind of this, it seemed more like there was a general policy that if you, that UNRWA in Lebanon was no longer able to fulfill its mandate. And I was wondering if you know if that's still kind of the situation, or if that trend has also followed in other national courts.
I'll take a stab at that. I have to admit that I'm not super closely following the Palestinian jurisprudence these days, because I've been working on a few other things. I think that the kind of trend from what I've seen and heard is that it's going to fluctuate depending on UNRWA's funding situation, because there was a real crisis towards the end of 2020 and ongoing into 2021. It's gotten a little bit better since then, but I don't think it's completely resolved. And I think it's certainly clear that UNRWA is not really able to adequately assist people in parts of its areas. And I think that it's going to have to be a question of fact in any particular case, as to unless there's an assessment by a particular government that they're going to just say UNRWA is not able to fulfill its mandate. I haven't seen much of that, but the Belgian cases are also really, really interesting, and it will be really fascinating to see what else happens in other countries. I think there is a bit of an increased awareness that UNRWA might not be able to adequately assist people and or protect people. And so I certainly hope that we'll see that kind of trend towards increasing awareness continue. But I would love to hear from others if anyone else has other information about that.
If I could jump in really quickly. I mean, just unfortunately, the current financial crisis that the UNRWA is facing is a huge challenge for it to continue meeting its and fulfilling its responsibilities towards Palestinian refugees in general. But then also in certain cases, asylum cases in Europe mainly, Palestinians were recognized as refugees or as stateless persons because UNRWA is not basically able to fulfill its responsibilities towards Palestinian refugees, but also because the interpretation of the exclusion clause 1D of the 1951 Refugee Convention was interpreted differently, the ipso facto element specifically. One of the very interesting cases, if I'm not mistaken, it was in Italy or France. I can look into this, sorry. My memory is not that great. But basically, the Palestinian asylum seeker was recognized as a refugee because of the inability of one, returning to UNRWA mandate, and two, UNRWA was unable to fulfill its responsibilities. I can look more into this case and email it to you or something, but yeah.
That would be great, thank you.
Do we have any more questions or comments for the panelists? No. Perfect. Then in that case, maybe I'd like to say thank you once again. Emily, do you have any final words?
Yeah, I just wanted to mention off the back of this project, we'll be launching a new training on statelessness focused COI research. So if you're interested in today and you're dealing with statelessness cases, we'd really love if you would attend. It will be free of charge, and we'll send you a follow-up email about those sessions in due course. And just thank you so much for attending today.
Thank you all. Thank you to the panelists. Thank you to the audience.
Thank you, everyone. Bye-bye.
Bye, everyone.
Bye.
Thank you.